This meeting is called to order. I want to thank everyone for attending this public meeting of the United States Sentencing Commission. The Commission appreciates the attendance of those joining us here, as well as those watching our live stream broadcast on the Commission's website. As always, we welcome and encourage the significant public interest in federal sentencing issues and the work of the Commission. I want to start by introducing the other members of the Commission. To my immediate left is Professor Rachel Barco. Commissioner Barco is the Siegel Family Professor of Regulatory Law and Policy at the New York University School of Law and serves as the Faculty Director of the Center on the Administration of Criminal Law at the Law School. To my immediate right is Judge Charles Breyer. Judge Breyer is a Senior District Judge for the Northern District of California and has served as the United States District Judge since 1998. To my far left is Judge Danny Reeves, who is a District Judge for the Eastern District of Kentucky, and he has served as the United States District Judge since 2001. And then to my far right is Zachary Boletho, who is the ex officio commissioner from the Department of Justice. Commissioner Boletho serves as Deputy Chief of Staff and Associate Deputy Attorney General to the Deputy Attorney General of the United States. The first order of business is a vote to adopt the August 17, 2017 public meeting minutes. Is there a motion to do so?
So moved.
Do I have a second?
Second.
Is there any discussion on the motion? So vote on the motion by saying aye.
Aye.
Any nays? The motion is adopted by voice vote. Before we proceed with the business of the day, I would like to update you all on the Commission's work. Last month, the Commission published its fourth report in its continuing series on recidivism entitled The Effects of Aging on Recidivism Among Federal Offenders, which examines the impact of aging on federal offender recidivism, and once age is accounted for, the impact of other offense and offender characteristics. Last year, the Commission also published 11 new reports on issues ranging from mandatory minimum penalties to an analysis of demographic differences in federal sentencing practices. And look for additional publications regarding mandatory minimums, recidivism, and other sentencing issues in the coming weeks and months. In August, the Commission voted to publish several holdover amendments from the previous amendment cycle. These proposals were not able to be fully considered previously because the Commission did not have a quorum for 3 critical months. In February, the Commission plans to hold a public hearing on some of these proposed amendments, including those that would implement the Bipartisan Budget Act of 2015 and recommendations from the Commission's Tribal Issues Advisory Group regarding how tribal convictions are treated under Chapter 4 of the guidelines. In March, the Commission will also hold a public hearing on another proposed amendment that was published in August, the proposed amendment regarding alternatives to incarceration and first offenders. That hearing in March would also cover any amendments we vote to publish today, in particular, the proposed amendment on synthetic drugs, which we will be voting on in a few minutes. The proposed amendment reflects the information we have learned from public comment and 3 public hearings we held on synthetic cathinones, cannabinoids, fentanyl, and fentanyl analogs last year. Before we move to the announcement of our proposed guideline amendments, the Commission would like to thank the numerous individuals and groups who submitted thoughtful comments and recommendations during our most recent public comment periods. As we ordinarily do in January, the Commission will now vote on whether to publish proposed amendments for the 2017-2018 amendment cycle. Our General Counsel, Ms. Kathleen Grilly, will now advise the Commission on the first possible vote concerning a proposed amendment on synthetic drugs. Ms. Grilly.
Thank you, Judge. The synthetic drug 3-part amendment before you is a result of the Commission's multi-year study of offenses involving synthetic cathinones, synthetic cannabinoids, THC, fentanyl, and fentanyl analogs. Each of the parts could be promulgated as they are not mutually exclusive. Part A of the proposed amendment would amend the drug equivalency tables in 2D11 to adopt a class-based approach to account for synthetic cathinones and sets forth a single marijuana equivalency for the class, bracketing 3 possible equivalencies: 1 gram of synthetic cathinone equal to 200, 380, or 500 grams of marijuana. Part A of the proposed amendment also brackets the possibility of making this class-based marijuana equivalency applicable to methcathinone and establishes a minimum base offense level of 12 for cases involving synthetic cathinones except those in Schedules 1, 3, 4, and 5. Part B of the proposed amendment would amend the drug equivalency tables in 2D11 to adopt a class-based approach to account for synthetic cannabinoids and sets forth a single marijuana equivalency for the class, bracketing 3 possible equivalencies. 1 gram of synthetic cannabinoids is equal to 167, 334, or 400 grams of marijuana. Part B includes a definition of the term synthetic cannabinoid and brackets for comment a provision establishing a minimum base offense level of 12 for cases involving synthetic cannabinoids except those in Schedules 3, 4, and 5. Part C of the proposed amendment would amend 2D11 in several ways to account for fentanyl and fentanyl analogs. First, it would provide penalties for offenses involving fentanyl that are equivalent to the higher penalties currently provided for offenses involving fentanyl analogs. Second, it would revise 2D11 by providing a definition of the term fentanyl analog, setting forth a single marijuana equivalency applicable to all fentanyl analogs of 1 gram is equal to 10 kilograms of marijuana, and specifying in the drug quantity table that the penalties relating to fentanyl apply only to the substance with a specific chemical name. Finally, Part C of the proposed amendment would amend 2D11 to provide an enhancement in cases in which fentanyl or fentanyl analog is misrepresented or marketed as another substance. Finally, each part includes issues for comment. A motion to publish the proposed synthetic drug amendment with an original comment period closing on March 6th and a reply comment period closing on March 28th, 2018, and technical and conforming amendment authority granted to staff would be in order at this time.
Is there a motion to publish the proposed amendment as suggested by our general counsel?
So moved.
Is there a second?
Second.
Is there any discussion on the motion? Vote on the motion by saying aye.
Aye.
Nay? No nays? Motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed amendment on immigration.
Yes. This proposed 2-part amendment responds to issues that have arisen regarding application of the illegal reentry guideline at 2L1.2. And the Commission is considering whether to promulgate either or both parts as they are not mutually exclusive. Part A would amend 2L1.2 by revising subsection B2 so that its applicability turns on whether the defendant engaged in criminal conduct before he or she was first ordered deported or ordered removed, rather than whether the defendant sustained the resulting conviction or convictions before that event. Part A would also make non-substantive conforming changes to the language of subsection B3. Part B of the proposed amendment responds to an issue that has arisen in litigation concerning how 2L1.2's enhancements for prior convictions apply in a situation where a defendant's prior conviction included a term of probation, parole, or supervised release that was subsequently revoked and an additional term of imprisonment imposed. This part would revise the definition of sentence imposed in application note 2 of the commentary to 2L1.2 to clarify that, consistent with the meaning of sentence of imprisonment under section 4A1.2, the phrase sentence imposed in 2L1.2 includes any term of imprisonment given upon revocation of probation, parole, or supervised release, regardless of when the revocation occurred. Each part also includes issues for comment. A motion to publish the proposed amendment with an original comment period closing March 6, reply comment period closing March 28, 2018, and technical and conforming amendment authority granted to staff would be in order at this time.
Is there a motion to publish the proposed amendment as suggested by our General Counsel?
So moved.
Is there a second?
Second.
Any discussion? All in favor say aye.
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 Any nays? The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. Our general counsel will now advise the commission on a possible vote concerning a proposed technical amendment.
Yes. This proposed amendment makes various technical changes to the guideline manual. First, the proposed amendment makes technical changes to provide updated references to certain sections in the United States Code that have been restated in legislation amending 2B1.5 and Appendix A. Second, the proposed amendment also makes technical changes to reflect the editorial reclassification of certain sections in the United States Code, making changes to 2A3.5, 2X5.2, 5B1.3, 5D1.3, and Appendix A. And finally, the proposed amendment revises subsection 8C2.1 by deleting an outdated reference. A motion to publish the technical amendment with an original comment period closing on March 6, a reply comment period closing on March 28, 2018, and with technical and conforming amendment authority granted to staff would be in order at this time.
Is there a motion to publish the proposed amendment as suggested by the general counsel?
So moved.
Is there a second?
Second.
Any discussion? All in favor say aye. Aye. Any nays? The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. I would like to take a moment to discuss briefly some of the proposed amendments. First, the commission is publishing a proposed amendment regarding synthetic drugs, which includes synthetic cathinones, otherwise known as bath salts, synthetic cannabinoids, including K2 or spice, fentanyl, and fentanyl analogs. The Commission has spent the last 6 months publishing various issues for comment and conducting public hearings on this subject. The Commission has used the expertise gathered through this process to craft a proposal to appropriately respond to this urgent issue. The amendment proposes a class-based approach for synthetic cathinones and cannabinoids and increases penalties for offenses involving fentanyl equivalent to the higher penalties currently provided for offenses involving fentanyl analogs. The proposed amendment also provides an enhancement in cases where fentanyl or a fentanyl analog is misrepresented or marketed as another substance. This month, the Commission will release a public data presentation for the 3 categories of drugs that are the focus of these amendments. Members of the public may find this information useful when preparing their public comment. Second, the Commission will publish a proposed amendment that addresses 2 miscellaneous application issues relating to immigration offenses. Finally, the Commission will publish a proposed amendment that includes technical changes to the guidelines. As we wrap up, I would like to mention an upcoming event, the Commission's National Seminar on the Federal Sentencing Guidelines in San Antonio, Texas, on May 30th through June 1st. This seminar provides training to probation officers, prosecutors, and defense attorneys on the guidelines. Registration for the event will open on January 22nd, so please look for the registration link on our website at that time. The Commission's proposed amendments and issues for comment will be on our website soon. We look forward to working with all of you as we move forward for another productive year. Thank you for joining us today. Is there any further business before the Commission? Hearing none, is there a motion to adjourn?
So moved.
Is there a second? Vote on the motion by saying aye.
Aye.
Any nays? The motion is adopted by a voice vote. The meeting is adjourned. Roll Tide.